Okay, this is 100, 120 class, and we're going to continue on with some briefs we've been learning. First of all, I'm going to review some. Bodily injury, BOJ. Great bodily injury, GROJ. Great bodily harm, GRARM. Physical injury, FOJ. Personal injury, PIJ. Oh, maybe you missed these, Kate, because I think that was Friday when you weren't here.
Are they on the list of them?
They're on this packet with all the rooms. It starts off with the rooms. It's multiple pages. Or it starts with the lights, I'm sorry. Green light, yellow light, red light. And it has the list of the rooms. We've been working on this, and we did the evidence ones. Excuse me.
Personal injury is POJ or POIJ?
I just have PIJ.
PIJ?
For
Personal?
For personal injury. You don't have that packet? Blue light, green, well, it's multiple pages, two-sided.
I'm the first page of it.
Okay. You know what? Maybe I need to get these to you guys. There's like 16 pages here. And you don't think you have it either? Huh. Well, somebody should have told me. Okay, so maybe I should just run and do this. Okay, getting back to these briefs now, and we have on the third page, we're going to go over these that have the second word injury. Bodily injury, excuse me, BOJ. Great bodily injury, GROJ. Great bodily harm, GRARM. Physical injury, FOJ. Personal injury, PIJ. Now some short phrases that end in the word knowledge. Direct knowledge. You'll notice I'm going to skip over some of these that I just do not think are very, very commonly used. Direct knowledge, DROJ. Personal knowledge, POJ. Indirect knowledge, NOIJ. Special knowledge, SPOJ. Acknowledge, that's a great one, AJ. Constructive knowledge, KRUJ. Okay, so we have bodily injury, great bodily injury, great bodily harm, physical injury, personal injury, direct knowledge, personal knowledge, indirect knowledge, special knowledge, acknowledge, constructive knowledge. Okay, now words that end in theft, or phrases that end with theft. Auto theft, AOFT, using the final FT for theft. EFT in many of these. AOFT is auto theft. Car theft, KREFT, car theft. Grand theft, GREFT, grand theft. Petty theft, PEFT, petty theft. Vehicle theft, VEFT, vehicle theft. Identity theft, long IFT, identity theft. Okay, we'll leave these departments because I'm guessing maybe these are new for you, what I've just introduced. Are they? Yes. Okay, we're going to stop with those then. So let me dictate some short sentences that will use the ones that we just went over. On the record, I suffered bodily injury. He was charged with great bodily injury. I sustained great bodily harm. She was subject to physical injury. He sued for personal injury. She has direct knowledge. He had personal knowledge of the event. Her testimony is based on indirect knowledge. The expert witness was able to offer special knowledge. Please acknowledge his presence. The expert had constructive knowledge. He was charged with auto theft. Auto theft is the same charge as car theft. Grand theft is a felony. Petty theft is a misdemeanor. Vehicle theft is the same crime as auto theft and car theft. Identity theft is a violation of law. Okay. I will put those aside, and I am going to do the Week 8 EV360 assignment next, which is a jury charge. Don't forget to come Wednesday with your laptops. Room, second period. We'll start at 9. Sorry, you weren't here. Start at 9:30?
9:45.
9:45, thank you. 9:45 in the lab, and bring your laptop, and Amit is going to walk you guys through downloading the EV360 Ultimate program. So you will have access to that, so you can start using that over the break and such. So I think you'll find it's very similar in its usage. What he's going to help you with, obviously, is not how to work EV360, but more so how to get it on your computer. It's not internet-based. Ultimate is not internet-based, so you should no longer have the Java issues and all those issues that have come up. And using the actual program, you will just log into it on your computer. And it's, I think, a little more user-friendly, but it's not going to look that much different than what you're doing. And the content is the same. It's just accessing it is different. And it does allow for some creative things that you can do on your own as well. Okay?
So we'll use that for our.
Yep. Correct. Yep. No charge and fee or anything. They just want to get everybody segued over, and with good reason. Okay, here we go. This is going to be jury charge. Also, put in your, if you keep track or whatever, June 5th, save the date. That's going to be our next CSR reception. I have a great speaker coming. I know she's going to be really motivational. And that's a Monday, June 5. That's Monday of the last week of classes. Not finals week, but the last week of the classes. Okay. So here we go with the jury charge, and that'll be at noon, so luncheon. We're going to start at 100, and I'll get us up to 130. On the record, ladies and gentlemen of the jury, the indictment in this case charges the defendant, Dupree Oliver. This is the wrong one.
Yeah. I just did it this morning.
You did it again for week 5?
No, I did the week 8 one this morning.
Oh, okay. Yeah, here's week 8. Okay, good. Here we go. Ladies and gentlemen of the jury, it is at this stage of the trial that the court will now give you the law that you must follow during your deliberations. The defendant, Pat O'Shea, has been charged with the death of Taylor Smith. The charge of the court is given to you to provide you with elements of the law that you are to follow during your deliberations. A copy of the court's charge will accompany you in the jury room when you commence your deliberations. Exhibits that were offered and received in evidence by the court will also accompany you in the jury room and should be considered by you, ladies and gentlemen of the jury, during your deliberations. Exhibits that were not received in evidence should not be considered by you. Opening and closing statements of the attorneys should not be considered as evidence in the case. These opening and closing statements were given to you by the attorneys as an overview of what the attorneys expect the evidence to show and what the attorneys would like you to conclude after hearing all the evidence and viewing all the exhibits in the case. Again, opening and closing statements are not evidence. The evidence you are to consider is the testimony received from the witness stand and the exhibits that were received in evidence by the court. Ladies and gentlemen of the jury, you must find that the defendant was aware of and consciously disregarded the risk of causing death. If you find that defendant was aware of and disregarded the risk of causing death, you must determine whether the risk that she disregarded was substantial and unjustifiable. In doing so, you must consider the nature and purpose of the defendant's conduct and the circumstances known to the defendant. And you must determine whether, in light of those factors, the defendant's disregard of that risk was a gross deviation from the conduct a reasonable person would have observed in the defendant's situation. All of the evidence relevant to recklessness, including any contrasting accounts of events by the defense and the state, must be considered by you. Another element that the state must prove beyond a reasonable doubt is that the defendant acted under circumstances manifesting extreme indifference to human life. The phrase under circumstances manifesting extreme indifference to human life does not focus on the defendant's state of mind, but rather on the circumstances under which you find she acted. If, in light of all the evidence, you find that defendant's conduct resulted in a probability as opposed to a mere possibility of death, then you may find that she acted under circumstances manifesting extreme indifference to human life. On the other hand, if you find her conduct resulted in a possibility of death, then you must acquit her of aggravated manslaughter and consider the offense of reckless manslaughter, which I will explain to you shortly. The final element that the state must prove beyond a reasonable doubt is that the defendant caused Taylor Smith's death. If there is a causal relationship between the defendant's conduct and the result of the conduct is not an issue, you must find that Taylor Smith would not have died but for the defendant's conduct. If causal relationship between the defendant's conduct and result is an issue, you must consider the definition of causation. Causation has a special meaning under the law. To establish causation, the state must prove two elements beyond a reasonable doubt. First, that but for the defendant's conduct, Taylor Smith would not have died. Second, Taylor Smith's death must have been within the risk of which the defendant was aware. If not, it must involve the same kind of injury or harm as the probable result of the defendant's conduct and must also not be too remote, too accidental in its occurrence, or too dependent on another's volitional act to have a just bearing on the defendant's liability or on the gravity of her offense. In other words, the state must prove beyond a reasonable doubt that Taylor Smith's death was not so unexpected or unusual that it would be unjust to find the defendant guilty of aggravated manslaughter. Where the defendant and state offer contrasting factual theories of causation, each version should be considered by the jury. If after consideration of all the evidence you are convinced beyond a reasonable doubt that the defendant recklessly caused Taylor Smith's death under circumstances manifesting extreme indifference to human life, then your verdict should be guilty of aggravated manslaughter. If, however, after consideration of all the evidence, you are not convinced beyond a reasonable doubt that the defendant recklessly caused Taylor Smith's death under circumstances manifesting extreme indifference to human life, you must find the defendant not guilty of aggravated manslaughter and go on to consider whether the defendant should be convicted of reckless manslaughter. A person is guilty of reckless manslaughter if he or she recklessly causes the death of another person. In order for you to find the defendant guilty of reckless manslaughter, the state is required to prove each of the following elements beyond a reasonable doubt. 1, that the defendant caused Taylor Smith's death, and 2, that the defendant did so recklessly. One element that the state must prove beyond a reasonable doubt is that the defendant acted recklessly. A person who causes another's death does so recklessly when he or she is aware of and consciously disregards a substantial and unjustifiable risk that death will result from his or her conduct. The risk must be of such a nature and degree that, considering the nature and purpose of defendant's conduct and the circumstances known to the defendant, his or her disregard of that risk is a gross deviation from the standard of conduct that a reasonable person would follow in the same situation. In other words, you must find that defendant was aware of and consciously disregarded the risk of causing death. Okay. I'm going to move this because honestly, I won't sit down. Whoa, this was not here earlier. Somebody really spilled something. I'm not looking at you like it was you. I'm sorry. I know who it was. I know who was sitting here. Oh, I see. Yeah, and it is wet. Now, it would have been nice to put some paper towels in or something. I'm assuming it's not just water. Yikesters. Okay. I'm going to do just one more little segment. It'll be 3 minutes from that jury's charge, and it's going to be a little bit faster. So hang on. Here we go. On the record. To establish causation, the state must prove 2 elements beyond a reasonable doubt. First, that but for the defendant's conduct, Taylor Smith would not have died. Second, Taylor Smith's death must have been within the risk of which the defendant was aware. If not, it must involve the same kind of injury or harm as the probable result of the defendant's conduct must also not be too remote, too accidental in its occurrence, or too dependent on another's volitional act to have a just bearing on the defendant's liability or on the gravity of her offense. In other words, the state must prove beyond a reasonable doubt that Taylor Smith's death was not so unexpected or unusual that it would be unjust to find the defendant guilty of aggravated manslaughter. Where the defendant and state offer contrasting factual theories of causation, each version should be considered by the jury. If after consideration of all the evidence you are convinced beyond a reasonable doubt that the defendant recklessly caused Taylor Smith's death under circumstances manifesting extreme indifference to human life, then your verdict should be guilty of aggravated manslaughter. If, however, after consideration of all the evidence, you are not convinced beyond a reasonable doubt that the defendant recklessly caused Taylor Smith's death under circumstances manifesting extreme indifference to human life, you must find the defendant not guilty of aggravated manslaughter and go on to consider whether the defendant should be convicted of reckless manslaughter. A person is guilty of reckless manslaughter if he or she recklessly causes the death of another person. In order for you to find the defendant guilty of reckless manslaughter, the state is required to prove each of the following elements beyond a reasonable doubt. 1, that the defendant caused Taylor Smith's death, and 2, that the defendant did so recklessly. One element that the state must prove beyond a reasonable doubt is that the defendant acted recklessly. A person who causes another's death does so recklessly when he or she is aware of and consciously disregards a substantial and unjustifiable risk that death will result from his or her conduct. The risk must be of such a nature and degree that, considering the nature and purpose of defendant's conduct and the circumstances known to the defendant, his or her disregard of that risk is a gross deviation from the standard of conduct that a reasonable person would follow in the same situation. In other words, you must find that defendant was aware of and consciously disregarded the risk of causing death. That was fast, huh? Try to get something for everything, but I know that was definitely too fast for you guys. It's tough stuff. Okay, this is a straight matter. This is actually going to be week 9 ZB 360, so I'll give you a preview. On the record. Her Republican colleagues made clear over and over again she would not have a seat at the new House Majority's extended leadership table. Representative Michelle Bachmann, they whispered, is too loud, too unruly, too Tea Party. But as the Minnesota Republicans strode out of the Capitol the other day and onto a leaf-strewn grassy park to rally a few hundred Tea Party activists, it was undeniable that she was their leader. If Speaker-to-be John A. Boehner is the commander of the 240-odd Republicans who will be seated in the 112th Congress, then Bachman is the ringleader of many of the voters who elected them. You are the people who changed the world the first Tuesday in November, Bachman told the crowd. You came out, you rallied, you called, you emailed, you faxed. They wouldn't pick up the phone and you kept it ringing. You're so persistent. You ran for office, you recruited for office, you donated for people running for office. You phone banked, you lit dropped, you leafleted, you persuaded. There's a chapter in the American history books written just with your name on it. And she added, the sun is shining down on us because you did it. Never mind that it was so overcast in Washington on this day that the sun could not peek through the clouds. In Bachman's Washington, it was nothing but blue skies. This was day one of freshman orientation for about 80 new Republicans hungry to do what Bachman has been preaching for months, to take on Uncle Sam, to slash the debt, to repeal Obamacare, and to restore the constitutional freedoms that an illegitimate president and his gangster government are taking from Americans. This is insanity economics, insanity politics, and it's not representative of who we are and this rich, beautiful legacy of 234 years, Bachman said. There will be a new sheriff in town, and this sheriff is going to listen to the American people. And if we don't, then you better turn us out too, because it's all about fidelity. Fidelity to the Declaration of Independence, that mission statement, the glorious mission statement that told us who we are and who we belong to. Here was Michelle Marie Bachman in her element, free from the confines of the Capitol, surrounded by adoring supporters, a rogue elephant with a microphone. With the rise of the Tea Party movement, the 54-year-old former lawyer has found national fame. Come January, what Bachman does with the platform her star status provides is an open question. How Boehner and other House leaders respond to her will be critical to the GOP's sometimes fraught relationship with the Tea Party. Earlier this month, Bachman tried to solidify her standing by running for a post in the leadership, but other Republicans saw no place for her. She bowed out of the race for House Republican Conference chair before the election, clearing the way for the preferred candidate of party elders, Representative Jeb Hensarling. When Boehner, Hensarling, and 7 other newly elected leaders appeared on stage at a news conference Thursday to present themselves as the new face of the GOP, Bachman, of course, was absent. Asked later how Bachman might factor in the party's future, Hensarling said, Michelle is a very good friend of mine. She's got my great respect and admiration, and hers was a very important voice in this election. I have no doubt that Michelle Bachman's voice will be heard at the leadership table and will be heard across the nation. To Democrats and some establishment Republicans, she is a sometimes loony purveyor of twisted facts and hyperbole who seems to spend more time on cable TV talk shows than she does in the Capitol. But to the conservative faithful, she is a smart and telegenic leader. Think Sarah Palin with a law degree, who fearlessly lends her voice and energy to the cause of restoring America's greatness. A mother of 5 and foster parent to 23, Bachman has represented for the past 4 years the middle-class northern suburbs of the Twin Cities and the independent populist farm towns beyond. Bachman raised more for her re-election campaign this year than any other House candidate, bringing in more than $11 million. She was one of the most in-demand Republicans crisscrossing the country, speaking to Tea Party groups and stumping for conservative candidates. Bachman rarely turns down an opportunity to deliver her message, although she denied an interview for this story. She finds a way to keep her TV hits in the news, such as on election night when she taunted MSNBC's Chris Matthews by saying, "We're coming out of our nightmare. I imagine that thrill is probably maybe not quite so tingly on your leg anymore." For the past 2 years, Bachman and a few allies occupied an empty stage in Washington. But with a new Tea Party-powered freshman class coming to town, that stage is getting awfully crowded. The competition for media and time and messages and leverage has shifted dramatically, and it's gotten to be more difficult for Michelle Bachman or me or a number of others to be able to convey a message. Representative Steve King, a Bachman ally and fellow Tea Party firebrand, said in an interview. Okay, that's some difficult material. I'll be the first to agree with you. I can't remember if we did this one. Oh wait, we're gonna do this one. Okay, this is more straight matter, different material though. On the record. You know, let's put a couple minutes of this on clean paper. We'll read this back, okay? It'll be slower. Here we go. Mr. President, I am quite upset and alarmed at a trend that seems to be gripping this great nation of ours. Throughout U.S. history, America has been a sanctuary for persons who hunger for freedom from religious persecution. Our forefathers, in their wisdom, paved the way for religious freedom. It was their goal and their dream for all people to have freedom of religious thought and freedom of religious expression. The Constitution of the United States of America, as authored by our great forefathers, states, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances." In the last several years, we have seen an alarming increase over the number of attempts to prohibit free expression of religious beliefs in nations around the globe. We have seen groups in the United States of America attempt to restrict freedom of religion through laws and regulations that prohibit freedom of speech and religious expression. Okay, I'm going to look at that for Rebecca. Okay, I'm going to repeat that section and go on now. Mr. President, I am quite upset and alarmed at a trend that seems to be gripping this nation of ours. Throughout U.S. history, America has been a sanctuary for persons who hunger for freedom from religious persecution. Our forefathers, in their wisdom, paved the way for religious freedom. It was their goal and their dream for all people to have freedom of religious thought and freedom of religious expression. The Constitution of the United States of America, as authored by our great forefathers, states, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. In the last several years, we have seen an alarming increase in the number of attempts to prohibit free expression of religious beliefs in nations around the globe. We have seen groups in the United States of America attempt to restrict freedom of religion through laws and regulations that prohibit freedom of speech and religious expression. Many groups, including the United Workers for Civil Liberties, have tried to prohibit prayer in the public schools. They have tried to prohibit the singing of anthems and songs that refer in any way to the Almighty. Lawsuits have been filed by the United Workers for Civil Liberties to eliminate any reference to God in textbooks across the United States of America. Mr. President, many of our citizens are afraid to speak out against any group that advocates the suppression of freedom of religion. They are afraid because some members of these groups are considered to be radicals. These organizations that are trying to suppress religious freedom are attacking doctrines and principles that have been around for over 200 years. Their beliefs and attitudes are not those of our forefathers of this great nation of ours. At this time, I would like to offer my support to my colleagues who hail from Iowa and Oklahoma. They have introduced SB 508. This bill is designed to protect the expression of religious beliefs throughout the United States of America. SB 508, in pure and simple language, establishes guidelines for schools and businesses to follow in order to ensure that the freedom to express one's religious beliefs and doctrines is safe and secure. SB 508 will protect the rights of every American to worship as they choose. SB 508 will give every American the protection and guarantee of freedom of religion and freedom of religious expression. SB 508 does not attempt to force non-religious persons to take part in organized religion. SB 508 is flexible and well designed to fit a variety of free speech issues as well as issues that pertain to religious freedom. Mr. President, I would like to close today and remind my colleagues of the original words to our national pledge to freedom, the Pledge of Allegiance of the United States of America. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I believe that pledge sums up both issues today, freedom of speech and freedom of religion. Gentlemen, you will find embodied in SB 508 phraseology that parallels both the First Amendment of the Constitution and the Pledge of Allegiance. If you study SB 508, you will find an extension of what our forefathers originally meant when they designed the Constitution to protect not only freedom of speech, but freedom of religion. Okay, we're going to go ahead and start takes. Okay, and we're going to start with a 120 straight matter. In this recording, and stop something.